Hi everyone, very good evening and welcome back to Crack Grade B. So in this particular session we are going to move ahead. We were talking about the consent, right? What are the situations in which consent is not considered as free, right? So we have seen so many situations out of it. We have seen that undue influence could be there. We have already seen that fraud could also be there. Apart from that, coercion can also take place. So these were the three situations that we have already seen. Now after this there can be also be a situation of misrepresentation and mistake, right? So all of these five together, if they are present, then they are considered as the case of not free consent was not obtained in all these five cases. It is assumed. Okay, so let us see about misrepresentation. Misrepresentation means obviously the name gives it enough clarity that truth is being misrepresented over here. Misrepresentation is release of deceiving details resulting in the presumption that party will enter into a deal. First of all, let us see the example. So A told B that his radio is in good condition. Because of the confidence he had in A, B bought the radio from him. Radio did not work properly after some time, so B thought he was misled by A. But A believed his radio was in good condition and had no intentions of deceiving him. Right? So here misrepresentation is in the part of A because he did not know that the radio is not working properly. Now in this particular case, what we are implying to say? We are implying to say that here A he was not having the intention to fraud Mr. B, right? He was not having that sort of sorry, he was not having that kind of intention. He already assumed that his radio was in good working condition. Sometimes it happens with us, right? If we think that okay, this thing might be working in a good condition, but actually it is not. So it might happen that A did not use the radio and he just said casually, no, my radio is in a good condition. But later on when B used it, he found it in a bad condition. So here the mistake was nowhere, but still it was a case of misrepresentation. Okay, A did not do it knowingly. There was no intention to fraud. अगर fraud वाली condition होती तो हम इसको ऊपर classify करते, right? Wait. Now next is the burden of proof. Burden of proof will be on the defendant to show that misrepresentation was not rendered fraudulently, right? Mr. A has to prove that there was no intention to fraud Mr. B, right? There was no intention of such kind. Now let us see the distinction between fraud and misrepresentation because both are kind of similar in nature. ठीक है, कुछ nature similar है, although they are not completely identical, but yes, there exists some kind of similarity. And let us see a quick difference between these two. So fraud is an intentional thing. It has been committed intentionally. Misrepresentation, it is a innocent mistake. What Mr. A did, it is an innocent mistake that was not done on purpose. ठीक है, जानबूझ के नहीं किया गया था. Section 17 में आएगा आपका fraud and misrepresentation. It comes under section 18. Okay. Was the intention to mislead other party? Obviously yes, right? In case of fraud, the intention was purely to mislead the other party. But in case of misrepresentation, ऐसी कोई intention हमारी थी नहीं, वो तो गलती से हो गया, right? So this is a sort of section for the innocent mistake. If I have to define the misrepresentation in short words, it will be called as the it will be called as an innocent mistake. Right, so that is the whole explanation again about it. Aggrieved party can claim the damages, right? Here we'll have no right to sue for the damages. क्यों कोई right नहीं दिया जाएगा? Because दूसरी पार्टी ने ऐसा जान के थोड़ी किया है, गलती से ऐसा हो गया, right? There was no intention to deceive, so that is why the right will not arise. Now, a similar kind of section, mistake, right? Misrepresentation, there has been an innocent mistake, right, where a fact has been misrepresented. एक fact को misrepresent किया गया है and it is an innocent mistake. But here we'll have a new section on the mistake, and what does it mean? It means there will be mistake that can happen on the part of seller as well as on the part of buyer. So we are going to see two forms of mistake over here. So there are two forms of mistake under Indian Contract Act, mistake of fact and mistake of law. ठीक है, मिस्टेक ऑफ फैक्ट का मतलब कॉन्ट्रैक्ट में कोई ऐसा फैक्ट था जिसके रिगार्डिंग कोई मिस्टेक हुई है, राइट? एनी सपोज वी आर एंटरिंग इनटू अ सेल ऑफ car related contract and there was a mistake in the contract related to the engine capacity of car. ठीक है, कार की कितनी इंजन की कैपेसिटी है उससे रिलेटेड कोई फैक्ट में मिस्टेक हो गई. ओके, दिस इज कॉल्ड एज मिस्टेक ऑफ फैक्ट. वेयर एज मिस्टेक ऑफ लॉ मीन्स you have done mistake in interpreting either the Indian law और the foreign law. या interpretation में आपसे कोई गड़बड़ हो गई हो, आपने comply नहीं किया, right? You have not complied or anything. The question is about law and here the question is about fact. Let us see. So mistake of fact arises when one or both of the contracting parties, they have misunderstood a term that is essential for the meaning of contract. It is never intentional. Such mistakes, they can be unilateral or bilateral. Unilateral means where only one party is at mistake and bilateral means जहाँ पे दोनों ही party at mistake हैं. What is bilateral mistake? Let us see. So when both the parties to a contract, they are under a mistake of fact essential to the agreement, it is called as the bilateral mistake. All the parties do not agree to the same thing and same way, which is the concept of consent. Since there is no consent, so contract will become null and void. ठीक है, हमने पढ़ा था कॉन्ट्रैक्ट, किसी भी कॉन्ट्रैक्ट को होने के लिए कंसेंट इज रियली रियली नेसेसरी एंड इन सच अ सिचुएशन व्हेन both the parties they have not arrived at meeting of mind. दोनों का meeting of mind है ही नहीं, so इस situation में क्या होगा? इस situation में contract will be called as a null and void contract because there is no meeting of mind. Okay, let us see unilateral mistake. Unilateral mistake, we understand what does unilateral mistake means, where only one party is at mistake. Fine. A unilateral mistake occurs when only one party makes a mistake. Contract will not be void in such a case. It is specified that the contract will not be void just because one party made the mistake. So if only one party is at the mistake, contract remains valid because the other party will make him understand and the contract can go on. ठीक है? So next is we have mistake of law. See, so you can do mistake in with respect to Indian law and foreign law, right? Now just before discussing this, we will have an informal discussion. अब एक बात बताओ, we live in India, right? It is assumed that we should know all kinds of rules and regulations. ठीक है, मैं I was driving my two-wheeler and I was not wearing a helmet. So मुझे ट्रैफिक पुलिस वाले ने पकड़ लिया, उन्होंने कहा कि अब लाइए जो भी है चालान वगैरह डिपॉजिट कराई है. So I said I was not aware that wearing helmet is compulsory in India. So he is going to ask me, are you a foreign citizen? You are an Indian citizen and you are supposed to know Indian laws, right? You cannot escape it. आप इसका बहाना नहीं बना सकते. Whereas being a foreign citizen, being a citizen of India, I am not, it is not compulsory for me to be aware about all the United States related laws. Okay? Similar thing applies for any foreign citizen which is who is in India, right? So in such a situation, इंडियन लॉज के लिए तो आप बिल्कुल एक्सक्यूज नहीं बना सकते, फॉरेन लॉज के लिए तो आप चाहे फिर भी बना सकती हैं. Mistake may be related to mistake of Indian law or it may be a mistake of foreign law. If the mistake applies to Indian law, principle is that law's ignorance is not a good excuse. This means either party cannot claim that it is not aware of the law. इसका आपको कोई benefit नहीं मिलेगा. Contract Act states that on ground of ignorance of Indian law, no party can claim any relief. This will also include incorrect interpretation of the legal provision. मान लो किसी law में कोई legal provision था and you have not correctly interpreted it, so that is also a problematic thing. वो भी तो एक problematic thing है, and you cannot say in the court of law that I was not aware about it. You cannot say this, right? This excuse will not be available to you. Next is, however, similar treatment is not given to the ignorance of foreign law. Ignorance of foreign law provides some leeway. Parties are not expected to know the foreign law, its meaning, and therefore under Indian Contract Act, an error of foreign law is actually treated as a mistake of fact. ठीक है, इसको fact की mistake की तरह देखा जाएगा. लेकिन if you are doing a mistake under the Indian law, then that will not be valid. Your contract will not remain valid. ठीक है. Done all the kinds of free consent related thing. So free consent is absolutely needful. Next we'll be talking about the unlawful object. It comes under section 23. So under section 23 of Indian Contract Act, certain restrictions have been imposed on individual while they are indulging in any agreement, right? So अगर आप कोई contract कर रहे हैं तो क्या expect किया जाता है आपसे? That you should be indulging in the lawful objects, right? Doing a contract related to narcotics, drugs related thing, doing a contract for killing someone, doing a contract for kidnapping someone. Are these lawful objects? Obviously not, right? So इस तरीके के अगर आप कॉन्ट्रैक्ट करते हैं तो पहली बात तो आपका कॉन्ट्रैक्ट तो वैलिड है ही नहीं, एंड डिपेंडिंग ऑन योर ऑब्जेक्ट इट कुड बी एन इलीगल कॉन्ट्रैक्ट एज वेल. ठीक. So under section 23, the objects matlab, what does object mean? Object means purpose for which you are doing the contract, right? So it is understood that even if consideration is purely valid, consideration से हमें कोई मतलब नहीं, although we will come on to consideration as well, but the first and foremost thing is that the object of doing the contract should be a valid one, right? You cannot do such illegal things. So similarly, if consideration is also defined under section 2D, if consideration is unlawful, then even if object is valid, contract will be considered as unlawful contract. What they are saying, object and consideration both shall remain valid. दोनों वैलिड होनी चाहिए, तभी हम आपके कॉन्ट्रैक्ट को एक वैलिड कॉन्ट्रैक्ट मानेंगे. If one out of them, be it consideration or be it object, if one out of them is not valid, is illegal, right, it is unlawful, then in such a situation your contract will also be considered as an unlawful contract. Okay, conditions of unlawful consideration and objects, what are these? You are doing a contract for the act which is forbidden by the law, like kidnapping and murdering someone. It is fraudulent. You are making a contract to fraud someone. It is such nature that it would defeat the provisions of any law. For example, income tax related. So me and my chartered accountant, we are doing a contract. I am telling him to pay the least tax that is possible by any measures. ठीक है. टैक्स में भी देखो अलग अलग चीजें होती हैं. एक होता है टैक्स प्लानिंग, okay, then you have tax avoidance, and then there comes also a place where you just want to escape the tax, right, at any cost, be it legal illegal. So अगर इस तरीके का आप कोई कॉन्ट्रैक्ट कर रहे हैं तो वो भी वैलिड नहीं माना जाएगा. Okay, let us see. Now the same things we are going to be discussing in a little bit detail. So unlawful object in a contract, number one, it is forbidden by law. So we have already understood what is forbidden by law. By any act of state or parliament, if it has been said कि भाई ये contract नहीं करना, right? Please do not do any contract related to such objectives, then you cannot do it. For example, production or sale of excisable articles are prohibited under the Excise Act except upon government license. मतलब कि the Excise Act was existent in earlier times, right? Even today, but there are on some limited commodities only. Now it has been replaced with GST. Now in such a situation, what happens is government says that if you want to manufacture certain article, you have to take a license from us. तो अब यहाँ पे license compulsory है. Now sale of liquor without license will be prohibited for this reason under the Excise Act, because इस पे excise duty लगती है. Okay, so if you are doing a contract for manufacturing, selling, etc., and you have not taken a government license, then this will not be a valid contract. It will be an unlawful contract. Okay, now there are some void agreements which have been forbidden by law. So A promises B to drop a prosecution which he instituted against B for robbery, while B promises to restore the value of things taken. It is void. Why? Because if somebody has done something which is against the morals and principles of the society, you need to report it. He has done the crime of robbery. He should be punished for it, right? इसके लिए उसको punishment मिलनी चाहिए. You cannot do a contract and you cannot say कि नहीं नहीं मैं तुम्हारे ऊपर केस फाइल नहीं करूंगा और तुम मेरी चीजें वापस लौटा दो. Not valid. Okay, where a loan was granted to guardian of a minor to arrange the minor's marriage has been held to be contrary to enactment of Child Marriage Restraint Act. इसीलिए तो ये act बनाया है. Why we have made the Child Marriage Restraint Act? To stop the child marriages, right? And if a person is taking loan to get a child married, now this is what? This is a unlawful object. This is an unlawful object, and this is not what you can say. It is not acceptable. Okay. Now the same things have been repeated. I don't think that there is a need for explaining this because we already understand. Defeat the purpose of provisions of any law. When something has been prohibited under the law, then this is not will not be called as a lawful contract. Next is fraudulent. Fraudulent means the agreement object of which to defraud others is void. Plain, right? You are entering into a contract with a person to fraud a third party. Now, is this a valid contract? Obviously not. In any case, it is not a valid contract. Injurious to person or property, you are making an agreement that implies and involves injury to another person. Suppose the two people are contracting among themselves and one person is saying that I will give you money if you will kill that person, right? So Hindi mein kya bolte, supari dena, right? So if you are doing such kind of work, is this a valid thing? Obviously not, right? It is an unlawful contract. Now, for example, if a person borrowed 100 rupees and in consideration executed a bond in favor of lender, also the plaintiff. Now you can read this example. I would like to tell you one thing over here. See, there is a difference. What is the difference? Suppose let us assume the horse example. I entered into a contract for selling the horse, right? But unfortunately, the horse died after 2 days. So I will call it as a void contract. मैं इसको क्या बोलूँगी? Void contract means it was a valid contract earlier, but later on it became void because the subject matter of the contract, that is the horse, is contract में कौन है subject matter? Horse, right? It died. So in this particular situation, we have to call it as a void contract. Valid contract became void because of certain conditions. अब यहाँ पे देखो, यहाँ पे जितनी भी conditions हैं, fraud वाली condition, injurious to persons, ये वाली condition, इन सभी situations में all these things are void from the beginning. there is no trace of being a valid contract. क्या ये valid थे कभी? ये कभी valid नहीं थे, right? They were void from the very beginning. So the correct term for them is void agreement. ठीक है? They are void agreement, at the same time they are illegal as well. ओके ये इलीगल है. वाई आई एम कॉलिंग देम एज वॉइड एग्रीमेंट? क्योंकि ये कभी कॉन्ट्रैक्ट बन ही नहीं सकते. दे आर नॉट एनफोर्सेबल इन द कोर्ट ऑफ लॉ. सो दैट इज वाई द करेक्ट टेक्निकल टर्म will be void agreement, because they are not allowed to be a contract. कोई contract बनने के लिए basic requirement क्या होती है? Enforceability, and unfortunately they are not enforceable. Okay. Few more conditions in which the object will be considered as unlawful. You are entering into a contract which is immoral. So for example, child trafficking, right? That is immoral. And if a person is entering into a contract which relates to child trafficking, then that is, first of all, it is a void agreement, and apart from that, it is an unlawful or illegal contract. ठीक है? Illegal है ये. It is not valid in India. Now, it is not valid anywhere in the world. Now, agreements opposed to public policy. Agreements opposed to public policy like trafficking in public offices, unfair dealings, interference administration of justice, marriage brokerage agreements, trading with the alien enemies, etc., etc. These are all opposed to public policy. Why? Because it restricts the freedom of person. अब यहाँ में marriage brokerage agreement में, if it is happening with the consent of the parties, right? I'm not talking about the platforms like shadi.com, etc. They are doing perfectly legal work, but I am telling where one person arranges the bride for the other person without the consent of the bride. Can I call it as human trafficking? Yes, I can call it as human trafficking. So this is not valid, and this is against the public policy, because as per Indian Constitution, everyone is having a right to life and everyone is having a फ्री कंसेंट. ठीक है? हम अपनी फ्री कंसेंट दे सकते हैं फॉर वेरियस डिफरेंट काइंड्स ऑफ एग्रीमेंट्स एंड कॉन्ट्रैक्ट. सो दैट इज व्हाई दैट वाज नॉट वैलिड. नाउ next thing we will be coming at performance of contract. Now, because we have almost reached at the end, so we will quickly go through these, because after this your contract act will be finished. There will be some specialized contracts that we need to talk about, so I'll be talking about possibly about them tomorrow. Okay, now performance of contract. Now contract will considered when as performed. It could be actual performance, attempted performance. Actual performance का मतलब, suppose we entered into the contract of sale of wheat and I sold the wheat to the other person. He gave me my money. So we actually performed both of our tasks, right? So performance हो गई. Now contract will be considered as completed. ठीक है? दोनों लोगों ने अपना अपना काम कर दिया. But here let's talk about the attempted task. Attempted task means, suppose we entered into the contract of sale of wheat and I told I was supposed to give delivery on 5th of July. ठीक है? 5th of July को हमें ये delivery देनी थी. So I told the other person, shall I deliver the wheat at your home? He said no, right? And after that he kept on saying no. बस नो 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 ही करता रह गया. कुछ उसने बोला ही नहीं कि कब डिलीवर करना है, कब नहीं डिलीवर करना है. Now I tried to deliver the wheat, but he denied, right? So here I attempted the performance, but he denied. So I am not at the mistake, and from my side I performed the contract. Let us see this. So complete performance by a party means contracting party has fulfilled every duty that has been required. Now what is substantial performance? Substantial performance is less than complete performance, but the level of performance is sufficient to avoid a claim of breach, right? Wait. Yes. So इतना perform कर दिया है that there will be no claim for the breach of contract. Sometimes it happens, right? Parties do file case onto each other for the breach of contract. Let us see the example. I enter into contract to build a house for Ellen. Build the house but fail to paint the interiors, right? Described in the contract. This contract is substantially performed and it does not give rise to the action for breach. So obviously, while paying, the other person can say that I am not going to pay you for the paint because you did not paint. So I will say yes, okay, fine. But substantial part, the construction of house has been completed. House का construction तो पूरा हो ही गया है. Although I did not paint, so I will not get the payment for that. But the majority task, suppose if we quantify it, 100 out of 100%, I have performed 90 to 95% of the task, so it will not attract the breach. Now what does breach of contract means? Let us see this. So any performance that is not complete, this entails performance at a level below what is reasonably acceptable. Suppose I entered into the contract for the construction of a house. Okay, I have built the walls but I have not laid down the roof. Okay, there is no construction of the roof. Now will it be considered as a substantially complete contract? Bilkul nahi, obviously not, right? This will not be considered as a substantial performance and the other party can file case onto me because the contract was to complete the construction of the house. I just raised the walls and did not do anything about the roof. So other party will file a case onto me for the breach of contract. ठीक है? Now let us see the mode of discharge of a contract. That means how the contract can be actually discharged. We are going to see this, but first let's see the through diagram. So the contract can be discharged, but that means can be completed. Number one, by performance, perform the contract. By mutual agreement. Mutual agreement का मतलब क्या होता है? आपस में एग्री करके कुछ चेंजेस करके या खत्म करके कुछ भी ऐसा आप एग्रीमेंट सॉर्ट ऑफ कर लो, राइट? नेक्स्ट इज बाय ऑपरेशन ऑफ लॉ. लाइक सपोज the one of the party died, there is a merger, the one of the party got insolvent, okay, other party did unauthorized altercations. If you did unilateral altercations, then in that case contract will not be called as a valid contract. Okay, impossibility of performance. For example, we entered into a contract for sale of horse and the horse died. Now the contract has become what? It is impossible to perform. By lapse of time. ठीक है, आपको contract, there was a contract to supply wheat for the 3 months duration and the contract was not completed within 3 months. So this will be called as contract will expire by lapse of time and by breach of contract. One party has broke the terms and conditions of the contract. So these are all the situations how a contract can be discharged. ठीक है, किस तरीके से contract को discharge किया जा सकता है. Let us see. By performance or actual performance. I have already explained you what does actual performance means. Whatever was expected out of you, आपको जो करने को बोला गया था, you have done that, right? अगर आपको कहा गया था कि you have to deliver wheat, you have delivered it. Okay, whatever has been told to you, you have done that. So this is actual performance. Attempted performance, I told you, I tried to deliver wheat, but the other party denied. दूसरी पार्टी ने मना कर दिया, तो मैं क्या करूं? जबरदस्ती लेके आऊं उसके घर? Obviously not, right? So I attempted the performance, but so that is why my part is clear. Now I can file the case onto him for breach of contract. Okay. Next is tender or the attempted performance can be of two types. Number one, if I was supposed to give goods, so I tried to give goods. Next, if I was supposed to give money, then I tried to give money, but the other person did not take. Matlab, whatever I was supposed to do in the contract, suppose if I was the seller, so I have to deliver the goods, that is my duty. So मैंने goods देने का try किया, and if I am the buyer in the contract, then I tried to give money. ठीक है, मैंने पैसा देने की कोशिश की. So tender means whatever you were supposed to give, you tried to give that. Okay. Essentials of a valid tender क्या होते हैं essentials? So it should be unconditional, means there should be no conditions. When I tried to give the wheat to the other person, that should be unconditional. I should have given whole quantity, right? It must be by a person who is in position and willing to perform. It must be at the proper time and place. I cannot say that I am coming at your home in the night, right, at around 2 a.m. That is not the correct timing. The other person is not expected to arrange the storage of goods. So the attempt should be at proper time and proper place. Proper form must be made to proper person. Suppose the buyer was not there at his business place. There was someone else, and he said that my owner is not over here, can you come after some time? So in this case, I cannot file case onto him because he is not the proper person, right? He is the servant. His owner is not there to accept my attempted performance. So in case of tender of goods, promisee must be given a reasonable opportunity to inspect the good. If I am giving wheat, I should give the opportunity to other person so that he can inspect, okay, what quantity, what quality of wheat I have given. Okay, so these are the few terms and conditions that one should one should keep in mind while attempting the performance. आप बोल रहे हो कि मैं तो गया था wheat देने बट सामने वाले ने लिया नहीं. Did you follow all of these? आपने क्या ये सारी conditions follow की? So this is also necessary. Now the contract can be terminated through mutual agreement as well. अब mutual agreement से कैसे terminate कर सकते हैं? Let us see this. So for number one is novation. Novation occur when a new contract comes into existence. So two parties have decided that okay, let us scrap the old contract and let us bring the new contract. ठीक है, दोनों पार्टीज ने म्यूचुअली डिसाइड किया है कि पुराने वाले कॉन्ट्रैक्ट को तो हटाओ एंड नाउ वी आर गोइंग टू ब्रिंग अ न्यू कॉन्ट्रैक्ट. Okay, either between the same parties or between the different parties. Now what is the important thing? Consent of all parties. Whatever parties were there in the old contract, they should agree with each other to change the contract or to bring the new contract. In case of novation, they are bringing the new contract. There is no talk about the changing. That comes in the alteration. Alteration का मतलब, it means change in the terms of contract. Contract remains the same. Like we have old contract, there is no new contract coming into picture over here. The same contract remains but with some changed conditions. कुछ नियम शर्तें बदल दी जाएंगी. Okay, again we need consent of all the parties. सभी की consent चाहिए, then only you can bring the changes. Next is remission. Remission means to accept lesser amount. Suppose I supplied the wheat to a person, the total bill was 1 lakh rupees. Now 4 months have passed. This person is not giving me my money. Okay, so I can say ki please give me 90,000 and let's finish this. Okay, I gave a discount to him. मुझे 1 लाख चाहिए था but I have accepted 90,000. I said तुम दो, अभी बस मुझे इतना ही दे दो, काफी है. This is called as remission. Remission means acceptance of the lesser amount. Okay, the example has been provided over here. You can just read it. अब recession का मतलब क्या होता है? Recession means cancelling the contract. You have dissolved the old contract, but there is no new contract coming into the picture. In case of novation, we have a new contract that is coming into picture, right? But in case of recession, no new contract is coming into the picture, और वही आपका पुराना वाला contract खत्म हो रहा है. Okay, next is waiver. Waiver means abandonment of right. Okay, so for example, waiver of farmers bank loan by the government. In such case, the bank give up the claim on the loan because government has said it. ठीक है, सरकार ने कहा है, इसलिए बैंक क्या बोलते हैं कि चलो ठीक है भाई लोगों, किसान भाई लोग, मत दो तुम पैसे. Next is merger. When the existing inferior right in respect of subject matter, it is merged with the newly acquired superior right, right? This is called as the merger of rights. Merger of rights means, suppose earlier I was only allowed to have 5,000 rupees, but later on I performed an additional service and now I am allowed 20,000 rupees more. So 5 plus 20 will be 25. So both these will be combined and now the person have to pay me 25,000 in together. Discharge by operation of law, very easy. If the person dies, if the person becomes insolvent, right? Merger means meeting of inferior and superior rights, so the inferior right will automatically vanish. अब वो दोनों एक ही हो गए हैं. With the lapse of time, contracts may be terminated by the lapse of time, right? Provisions are stated in the Limitation Act. Limitation Act भी है आपके syllabus में, so we are going to read about it as well. For example, money related suits should be filed within 3 months, otherwise they will become the time barred. And next is the supervening impossibility. That is, it is impossible to do the contract. For example, I told that the horse has died. Our subject matter has got destroyed. So this is also the destruction of subject matter is also one of a valid reason. Contract which at the time was entered, it was valid to be performed. Now it has become the impossible to perform. It is called as the doctrine of supervening impossibility. Now, how this impossibility, supervening impossibility may occur? Number one, destruction of subject matter of the contract. Next is law has changed. That means the on the basis of a law on which you were going to make a contract, that has changed. For example, maternity benefit related law has been changed. The timing of that has been changed. So a company which was doing a contract with its employee has to change the terms and conditions because the earlier one will not be valid. ठीक है? Non-concurrence of the circumstances. So for example, A and B had a contract to marry each other. Before the time fixed for the marriage, A goes mad, right? A pagal ho jata hai. So in this case, contract will become void because the conditions are not same. The time when contract was entered, तब conditions कुछ और थी और अभी conditions कुछ और हैं. Death or incapacity for personal services. So where the personal qualification of a party is the basis of contract, right? So in that case, the contract will become invalid. Suppose I have a AC in my home, right? The AC was needing for some repair. So I called up a person. He said that I will come but at a later date. Now, if unfortunately that the person dies, in such a situation, contract will not be able to perform because this contract was based on his experiences, right? Personal experiences. He is having the experience of doing repairs. Now, nobody else can fill in his shoes. उसके अलावा कोई और नहीं आके ये काम कर सकता, right? So this is why this contract is will not be remain valid. Failure of ultimate purpose of the contract. Next is outbreak of war. So suppose a contract entered into war with an alien enemy is void ab initio. Let us assume theoretically that one Indian national did a contract with a Chinese national. At the time at which contract was entered, there was no war between India and China. But subsequently, a war happened between India and China, and now during that war the contract that has been entered into will become void. ठीक है, because the other person has become a alien enemy. Discharged by lapse of time, already discussed. Discharged by breach. So when a contracting party refuses or fails to give the performance, it is called as the breach of contract, right? It could be actual breach or the anticipatory breach. What is actual breach? When you have defaulted on the date of performance, this is called as actual breach. You were supposed to pay me 10,000 rupees on 10th July. If you said no on 10th July, that is actual breach. मतलब जिस दिन you have to perform, on that day itself you said I cannot perform. This is actual breach. What is anticipatory breach? You were supposed to give me 10,000 rupees on 10th of July, but you said on 7th itself that I will not be able to pay. This is anticipatory breach. ठीक है, जहां आपने पहले ही मना कर दिया. Now, a quick review of the types of damages that can be awarded as a remedy for breach. See, if the one party is breaking the contract, we cannot let the party go like that. You have broke the contract, now you have to pay the breach as well. That means you have to pay the damages as well. So number one is we have the ordinary damage. It is recoverable damages which are natural and the probable consequences of the breach. Okay. So suppose you did not buy the tomatoes from me and now the tomatoes have got rotten because that is a perishable commodity. Now you are liable to pay me the money for the tomatoes. Okay. This is ordinary damage. Then we have special damage. These are recoverable if the only parties knew about it. Right. For example, when I was entering into a contract, I have a steel manufacturing unit, right? You demanded steel from me in large quantities. I told you that, see, if you will breach this contract, then there will be extraordinary damages that you need to pay. Why? Because I will not be able to get the suitable buyer for them at short notice. So अगर आपने पहले ही बता रखा है that there will be damages for it if you breach the contract, extraordinary damages, then that comes under the special damages. Okay. So thus these damages, they cannot be claimed as a matter of right. They are not recoverable unless the special circumstances was brought to the knowledge of defendant. That means you have to inform at the time of making contract itself that if this contract got breached by you, then you will be liable for special damages. तो अगर आपने पहले बता रखा है, if you have already informed in advance, in that case you will be able to recover special damages. Indirect damages, these are not recoverable. You are only allowed to recover the direct damages which has happened because of the breach of contract. Otherwise, no. Nominal damages means there is no loss to the other party, but still the other party who has defaulted has to pay some amount of damages. This is called as nominal. कि आपको देना तो है. Why? Because you have performed a bad deed. Means you have not completed the contract and we cannot let you go like this. Although there is no loss, but still you have to pay the damages. Okay. These damages are granted by the court to merely acknowledge that plaintiff has proved his case and won, and the other party has defaulted on the contract. Now there are few exceptional things that we are going to see. Wait. Contingent contract क्या होते हैं? So a contingent contract, it is contract to do or not to do something if some collateral event happens. For example, A contracts to pay B 20,000 if B's house is burnt, right? So here the payment will happen when a contingent event will happen, means the happening of this event is not sure. Are you sure that his house will go on fire? No. So this is a contingent event. It may happen, may not happen. So if it happens, then 20,000 rupees will be paid. So this is a contingent contract. Now, when this contract can be enforced, when that contingent event happens. Okay, जब वो contingent event होगा, in that case, if B's house has got burned, after that only B can enforce that contract. उसके बाद ही B बोल सकता है कि भाई अब मुझे 20,000 रुपए दो. उससे पहले नहीं बोल सकते. ठीक है, उससे पहले बिल्कुल नहीं बोल सकते. Now, performance must be conditional, right? The performance, that means paying of 20,000 rupees, should be dependent on a future event, and that event should be uncertain. Number one thing. Okay. Next is the said event must be collateral to such contract. The event on whose happening or non-happening of the event on which the performance of contract is dependent should not be a part of consideration of the contract. So said event must be collateral to such contract. Said event must be collateral to such contract means, like we said in the example, it has been given that A and B, right? A said to B that I am going to pay you. In such a situation, what will happen? If B's house will get burned, then in this case both the conditions are written into the contract only. ठीक है, contract में ही लिखा हुआ है. So in such a situation, event should be collateral to such contract, and the event should not be at the discretion of promisor. Should not be discretion of promisor का मतलब क्या होता है? That the promisor should not be having discretion onto it. See, if promisor will have certain kind of control onto the event, then he can mold the contract in his favor. ठीक है, अपने favor में कर सकता है, right? So in such a situations, the event should not be in the control of either of the parties. For example, fire in the B's house, although we can say that this can be controlled and anyone can fire that particular house, but still we will assume that it is not going to happen by a human act. If it happens accidentally and if it is out of the hands for the other two parties, then only event will be called as an uncertain event. For example, happening of earthquake, right? Earthquake is not in the hands of either of the parties. So this is purely uncertain event, and this can be a valid consideration for a contingent contract. ठीक है? So this enforcement related things already done. Now there are few contracts, quasi contracts, etc. These quasi contracts we have already talked about it when I was explaining you the types of contract. Quasi contract means where the two parties, they are not intentionally entering into contract, but because of the situation they have to enter into contract. For example, we talked about it initially as well. Necessary supply to the person who is incapable of contract. For example, minor. ठीक है, minor को दिया गया है minor needed some necessities, means suppose he needed food but he is not capable to contract. So in such a situation, what is going to happen? In such a situation, his property will remain liable and a kind of contract has been created. Okay, next is payment by an interested person. So all of this we have already talked when I was explaining you the types of contract, right? So this is it. Indian Contract Act we have finished. There are some special kinds of contract that we will understand in the later time period. Thank you so much for joining in.